Bratty, Attorney General for Northern Ireland, 1961, 3 all ER 523, a House of Lords decision relating to automatism. The court decided that a medical evidence is needed to prove that defendant was not aware of what they are doing. If this is available, the burden of proofs lies with the prosecution to prove that intention was present. Fact: the families of the George Bratty, 26, and Josephine Fitzsimmons, 18, were friends who lived near Hillsborough on December 1960 22. Bratty went to this Josephine house at 8:40 to deliver Christmas boxes. Then this Josephine asked Bratty to drive her through her over the back of the drive to Hillsborough to get some sweets. He did so. When they are coming back, Bratty, in a moment of automatism, caught Josephine, threw her over the back of the car, and strangled with her own stockings. In the struggle, he received a 2 scratch mark on the neck, which were discovered on his subsequent examination. After killing her, he threw her dead body on the road. He was found a Grove Road on the grass where he had not been sexually assaulted, but her underpants has been removed. Were found with her left boot on a short distance from the body on the grass at 4 p.m. 4 a.m. 23:16. 23:60. Bratty was arrested. He was examined at 1 p.m. same day. 2 scratches were on his neck also. When asked what caused him, he rightly told that Josephine had caused them. Also narrated the entire story correctly. He said that he had a blackness before committing the act and that I did not realize what exactly I was doing. He said that previously he had a feeling of blackness 4 or 5 times previously. There was evidence too of his odd behavior at times, his mental backbenders and his religious leanings. Bratty was convicted at the Down Patrick Assizes by McVeigh on May 1961. The Court of Criminal Appeal in Northern Ireland, the Lord McDermott, Black and Curran Appeal Convention. Bratty appealed to the House of Old Issue. Bratty suffered from psychomotor epilepsy. The act of killing was an act of automatism resulting from that. 3 doctors specialists. He gave evidence behalf of the Crown, said that possibility of an epileptic attack could not be ruled out. All the doctors agreed that psychomotor epilepsy, if it exists, a defect of reason due to disease of the mind. So the counsel for the defense requested the jury to find one of the 3 separate and independent verdict, not guilty, because he was accused in a state of automatism at the time when the homicide occurred. If this defense were rejected, defense can then ask for a verdict of manslaughter on the ground that the accused was at the time of the act incapable of forming the particular intent required for the murder. Following either of these 2 verdicts, it was said that jury become a verdict of guilty, but in same decision judgment delivered on October 1961, the Bratty was found guilty. Reasoning: the defense could not prove that the actions of Bratty were unconscious and involuntary. Bratty had always been well behaved and orderly. He was quiet and kindly. His actions on the 22nd December 1960 seemed out of keeping with his character. He only said that he could not remember his action. An act is not to be regarded as an involuntary act simply because the door was not remembered. When a man is charged with dangerous driving, it is no defense to him to say, I don't know that happened, I cannot remember a thing. Loss of memory afterwards is never a defense in itself. So long as he was conscious at the time, Bratty appeared conscious at the time he was doing the act. Thank you.